I'm Jim Gordon with Beers and Gordon. I want to talk to you about no-fault law. No-fault law, we get calls all the time. People say, what do you mean by no fault? All that means is personal injury protection insurance. So years ago, Florida instituted a system where they gave everyone had to purchase personal injury protection insurance. It's one of the two coverages you're required to have. What personal injury protection insurance does is it allows you to treat after a motor vehicle accident for up to $10,000 of treatment, even if you're not at fault, or if you're at fault, for the accident. So you can be at fault or not at fault. David, I think it started just a couple of years before you started practicing, right?
Yes, prior to the adoption of the no-fault law, Florida was among the majority of states that based its recovery on personal injury cases on fault. But the no-fault law was intended to limit the number of potential lawsuits for personal injury victims to those victims who could only establish that they had a permanent injury within a reasonable degree of medical probability.
And the interesting thing is when that started back, I think you said maybe the early 70s is when it started, is it was $10,000 of treatment. It's still $10,000 of treatment, 50, almost 50 years later.
Right.
That they haven't changed that. They keep trying to tweak the law, and they tweaked it, I think, in the last 2012, and it came into being in 2013. But it's one of those areas of law that the legislature is always trying to mess with to try to change it, because we're one of the few states left that even have that type of law.
Correct. I would like to see, and I think most trial attorneys who represent victims would like to see a path towards Florida going back to a fault-based system, because that's more consistent with our approach to social justice in this country, where fault is the deciding factor as to whether compensation is to be earned and established or not.
And one of the frustrating things is when our clients ask us all the time about using their PIP insurance, is you're required to use it, number one.
Right.
So there's nothing they can do about that. Health insurance is not going to kick in until the PIP benefits have exhausted. And the concern is, are my insurance rates going to go up? And the legislature said years ago, you can't raise the rates for using PIP benefits because it's required. And we tell our clients that, and that's the truth. The problem is, if the insurance company can find any other way to raise your rates, another previous fender bender, a big ticket, anything that they can find in your history to raise your rates, they're going to use it. And I have to tell clients that even when they use PIP. And they also have to be careful. We talk here, we're not just talking about law. That's the reality of what we try to do. We talk to other people and we talk to insurance agents, and insurance agents have told me and told you the same thing. Years ago, we learned this when we first started practicing as victim attorneys, is if you have 2 PIP claims in a 3-year period, that makes you very difficult to insure. So we have to give that advice. And that's why it's important to talk to an attorney when you're involved in an accident. Call us, we're gonna tell you the truth. I've had clients call me and I've represented them before, and I say, well, how hurt are you from this subsequent accident? Because if you make a PIP claim, even if it's only one visit, that PIP claim now is on your record for 3 years. That's important. We're gonna have those discussions with people. We're gonna have those discussions with clients on whether or not they should ever make a second PIP claim, because it's a practical concern that they have, right?
Oh, absolutely. The market being the way it is, the insurance companies have very carefully analyzed what their risk factors could be for someone who's had multiple PIP claims. So unless you have an injury that you're going to be treating for, it would be wise to limit the number of PIP claims you file.
And it's frustrating, because if you're in an accident 6 months apart and both of them are not your fault and you need to get treatment, you have to use it. And then they use that against you, and that's really not a fair system. But those are discussions that we're certainly going to have with you if you call our office, whether it's just a call or a consultation, or whether you're our current client. We're going to have all those discussions with you. So if you need that kind of help and you have questions about no-fault insurance, please call us at Beers and Gordon, 407-862-1825, or visit our website, beersandgordonlaw.com.